literally from county to county to county. So we've got Collin County, Hayes County, one in McLennan County, one in Belton County, one in Kaufman County.
This isn't one mistake,
This is the first red flag for the court. Judges don't just look at what happened, they look at how often it happened and where. When crimes follow the same pattern across multiple counties, it signals intent, not accident. At this point, the court isn't asking if she stole, it's asking why nothing has stopped her yet.
the pattern. County to county, case to case, theft after theft. She's not confused or unlucky. She's been convicted, sentenced, and kept going. Now the judge sees the full picture. No excuses today. Guilt isn't the question, patience is. And the court may be done being lenient.
Good morning. Are you Contasia Richmond?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Richmond, in cause number 24, DCCR 2306, you're charged with the state jail felony offense of theft with previous theft convictions from September 9th of 2024. The indictment alleges you were previously convicted of theft June 21st of 2019. And then after that was final, you were convicted of theft in 2 cases on the same date, March 21st of 2024 in Bell County, and then again April 10th of 2024 in McLennan County, Texas, and May 31st of 2024 in Collin County, Texas. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And are those prior convictions true?
Yes, ma'am.
Here's a key legal moment most people miss. By admitting the prior convictions are true, she removes the court's ability to treat this like a low-level theft. Prior convictions legally enhance the charge and expand the judge's sentencing discretion. This is where leniency quietly leaves the room.
What are the outcome of those last few, 2024 cases?
Judge, I've got the one with 2023 where she in Hayes County. Is that the one? I believe that. Is that
I don't even have a 2023 Hayes County in here. I've got
I've got
2 in Bell County, 1 in McLennan, and 1 in Collin.
Collin. We got 200 days in county jail,
Okay.
and Bell County was 9 months.
What about McLennan County?
I think it was a misdemeanor. 4 months.
I believe
Okay.
most of these were punished as a misdemeanor, 1244. Judge.
Well, you've got one. The Bell County's out of a district court,
Yes, ma'am.
and the Collin County's out of a district court, which they could have pled them down, but those are both.
This is a state jail. The Bell County was the one in 2024. It's 9 months state jail. And the Collin County one, like you said. I know. The Collin County was a 1244 to be specific, Judge.
This confusion over prior cases actually hurts the defense. When records from multiple counties stack up like this, judges grow skeptical fast. Even when sentences were reduced or downgraded before, the pattern still counts, and judges are allowed to consider the full criminal history, not just what's convenient.
Okay. Let me look at something. I don't think I like it. So there's a case from 2017 here out of this court for a 2-year term in prison. What was that for?
No, I had 2 years probation, and then when I went to jail, I had got some jail time with a 1224. I don't know how much it was.
So what I'm looking at here, which is even more than what's included on that indictment, shows a 2017 conviction for theft here in Jefferson County, a 2023 in Collin County, a 2023 later that year in San Marcos.
Hayes County.
I was
Hayes
in jail
County.
that whole time.
I don't care if you're in jail. I care that you're continuing to steal, and that I'm not sure that this deal that you've made is sufficient for what I think, for what you've been doing. So we're not talking about a long time ago. We're talking about the last 2 years.
This is the turning point. The judge isn't limited to the indictment anymore. She's evaluating behavior over time. Multiple thefts, multiple counties, back-to-back convictions. That tells the court rehabilitation failed. The question shifts from what's fair to what finally works.
That's the moment the room shifts. The judge isn't limited to what's charged, she's looking at the pattern. Multiple thefts, multiple counties, stacked back to back. This isn't history. This is recent behavior. And it tells the court everything it needs to know.
So going from literally from county to county to county. So we've got Collin County, Hayes County. Then we're into 2024 where there's 3 convictions, one in McLennan County, one in Belton County, one in Kaufman County. And we're back here with an offense date. So the offense date here was 9/9, which is actually of 24.
Yes, ma'am.
Okay. So at least that one was before the Kaufman County. So you went from here and then you traveled to Kaufman County within 3 days, got another case there. Or at least you had it before and that was the conviction date. Yeah, nope. I will keep the paperwork. Y'all can go visit. I don't think 12 months is appropriate somewhere. So there's got to be a little more than that, in my opinion. Otherwise, obviously, jail time has not been sufficient to deter.
Listen carefully, jail didn't work. Probation didn't work. Short sentences didn't work. The judge said,
Listen carefully here. This isn't anger, it's judicial logic. Jail didn't work, probation didn't work, short sentences didn't work. When deterrence fails, courts escalate consequences. That's not punishment for punishment's sake. That's the system trying to interrupt a pattern that won't stop on its own.
as it plainly, deterrence failed. When punishment doesn't change behavior, the court has one option left. Increase the consequence until the pattern stops.
Ms. Richmond, from going county to county and stealing places. So y'all take another look at it. I won't delete it. So if y'all come up with something, I can make that adjustment. If not, if you need some time, I'll reset it and then y'all can talk.
Yes, ma'am.
Miss, okay. And we're back on the record. Cause number 24, DCCR 2306. Mr. Hocko.
Your Honor, they've agreed to offer 18 months in this case.
And is that an agreement that you've talked to your client about?
We have discussed that. Judge, Ms. Richmond is willing to take the 18 months, yes.
Ms. Richmond, with everyone's permission, I can make that adjustment on this paperwork. I want to make sure it is your understanding that you are now agreeing that I sentenced you to 18 months in your case. Is that correct?
Yes, ma'am.
And you understand if I follow that agreement that you'll be waiving or giving up any right to appeal. You can't change your mind later and say she gave me 18 months instead of 12. You are now agreeing to that 18 months, correct?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Richmond is not competent?
No, Your Honor.
All right, I'm going to find, Ms. Richmond, that you entered your plea of guilty and true, freely, and voluntary. Well, I'm not even sure. Let me go back just to make sure. I do want to go back to that indictment. Are all of those prior convictions for theft true?
Yes, ma'am.
And are you pleading true because those are actual convictions that you received?
Yes, ma'am.
All right, then I am going to find, again, sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed.
An agreed 18-month sentence means one thing. This outcome was chosen, not imposed. The defendant waived appeal rights, accepted responsibility, and locked in the deal. So here's the real question. Did the judge wait too long to draw the line, or was this final chance already overdue? Drop your take in the comments.
And so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. A firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, ma'am. You can go back with the bailiff. All right, let's get Brandon Bell, please.
18 months isn't about revenge, it's about reality. The judge weighed the choices, the record, and the repeated chances already given. This sentence wasn't forced, it was earned. So here's the question. Was the judge right to draw the line now, or did the defendant burn her final opportunity long ago? Comment below, hit like, and subscribe for more real courtroom breakdowns.